The first thought is that one, just because AI is involved doesn't necessarily mean that it's a protectable invention. Um, and look, we saw this when digitization first really took hold from a consumer standpoint. Like, if it's the same algorithm but a computer helps you do it faster, it's not going to be protectable.
Hello, everyone, and thank you for joining the Digital Shift. I've been really looking forward to this one because I have a special guest today. I was looking through Verna Law's site, and Anthony has built such an interesting niche around intellectual property and business law for creative and tech-based companies. And I really love how he positions his firm to not just protect, but strategically grow his clients' brands, inventions, and work. To set the tone for this conversation is truly casual. There's no scripted questions. We have a full conversation. We're here to explore Anthony's stories, the insights from his experience, and what's shifting in today's trends and looking into the future. So, Anthony, welcome to the show. Let us know where you're calling in from today and tell us a little bit about yourself.
Darren, it's a pleasure to be here. Thank you so much for having me on the Digital Shift. I am coming in from Westchester County, New York, so we are north of New York City, and basically where we are is almost right on the Hudson River, so it's always a great, pleasant, and calm view to stare out the window in the morning.
Well, they always say that being next to water is good for the soul.
And now that I've been doing this for 8 years, yes.
Well, awesome, Anthony. For those of you that are tuning into the show for the first time, these interviews and podcasts are about 30 to 40 minutes to where we dive into four key sections. The first one is going to be focused on his background and what motivated him to start his company. From there, we actually look at the industry, the trends that he's seeing, and how he's pivoting to win with those trends. From there, we then look into the future as well. We're trying to find out what the future looks like in the next 6 to 12 months. And then we also focus on Verna Law and talk about what he's doing in his company that's working today and the challenges that he's struggling through. So buckle up. This is going to be great because it's always an honor to have an Esquire on our call to provide a very unique approach to cybersecurity and technology. So, Anthony, going back to it, just share a little bit about your background and what inspired you to found Verna Law.
Thanks very much, Darren. So, going way back to my college days, which I can't really believe is almost at 30 years at this point. But I have a bachelor's in computer science, and by the way, way back then, we programmed in Pascal, Basic, Fortran, and then C++. So and then my second job out of college. So my first job out of college was in C++. My second job out of college was in Visual Basic, which, at which point I waved the white flag. I'm like, man. But I never stopped being a nerd. And when I went to law school and I saw what I could do, and eventually I decided to, take this route into, intellectual property, much, I'll just say generally for now, but like it's kind of this mix of me where it's law, it's business, it's tech, it's art. Like you take it all in one big gigantic bundle, and it scratches a whole, all different aspects of my brain and my personality. So that's why I decided to move into IP once you get past the basic stuff, and you just see what you can see. My first law firm was a small firm outside Philadelphia, which is where I'm from originally. And after 2 years there, I moved up to New York, and said, let's see what I can do. I was at a big firm called Paul Hastings. These days it is just called Paul Hastings officially. Those days they had some other names at the end because law firms like lots of confusing last names in them for some reason. But I worked in the patent litigation department while I was there for the 2 years, and then hung my shingle and got things rolling. I had a partner for about 5 years there, and she these days she's I mean she was older, so these days she has generally retired from practicing law, and now then I rehung my own shingle and have grown. And we are a boutique firm. Me, it's another attorney who's out on the West Coast and our patent agent as well. So that's the background for you.
So, was there a specific case or moment that made you realize that you wanted to own your own firm compared to working for others?
So it was probably still at my first firm. The owner of that firm was just he was way out, not just in left field, but like in the left field bleachers. I mean, I mean, we had six lawyers at one point, and then everything crumbled. And at that point, I was like, okay, well, if this, if he can get this semi working, I think I could probably get something, you know, semi working as well, and do better. I mean, I had two paychecks bounce at my first firm, and we were an IP firm. It was kind of ridiculous, to be honest with you. And so I had decided even then at some point I do want to open my own practice and start building and because I knew that I could do that better than what he did.
Gotcha. That actually seems to be a pretty common theme is, it's
Work
like, man,
working
like these companies are making all this money, like I can do better.
right, working for a crazy person, and you're like, I could do better than this. Yes, I can.
So, as the owner of Verna Law, what does a typical day look like for you?
Well, I would first say that there's probably not a typical day for me, because what's great about the way I've structured the practice is that no 2 days really are the same. And I know that saying that is a bit of a cliche in and of itself. But, for example, on Tuesday, I actually had to walk into federal court, which it happens less and less these days because, hey, judges have discovered telephone conferences and Zoom and Teams and WebEx. And it's kind of funny how federal court has changed since the pandemic. But on Tuesday, I actually had to walk into federal court for a conference, and the judge got to, um, basically look at defendant's counsel and say, "Hey, plaintiff's settlement offer looks good. Why aren't you taking it?" So there was that, and then the next day I had a video, a telephone conference call for federal court. So I mean, the same thing, but just approached in two very different ways. Um, some days are spent just writing a motion, which was what my yesterday was. Spent just checking off documents that needed to be written for one of my cases. And then some days, of course, we're working on filing intellectual property, on filing patents, trademarks, and copyrights, and getting it done. So I wish I could sit here and say there was a typical day, but some days are full of meetings, some days are just head down in the keyboard.
So, with those days, or with the clients that you're actually working with, what are the typical types of climates that you're working with? And then what kind of IP challenges do they usually bring up most often?
So we have a range of clients. I mean, yes, we do work. We work with startups and solopreneurs a lot. We have worked with companies whose ongoing businesses are somewhere between they're somewhere around $4 or $5 million as well. So we have a real range of clientele at our firm, which does keep us on our toes and does keep our brains engaged and everything, because everybody's needs are different. um what we're working with, when we're working with the small companies and the solopreneurs, their patent needs, for example, are very different than the company that's already well funded, because the founders, we have a situation with the client right now where the founders are well funded because they've had 6 or 7 exits, and like, look, we've got this product and this is what we want. And on one hand, we're trying to, when we're filing a patent for a solopreneur, it's like, how can we describe the product broadly enough without killing the budget for that particular client. What kind of protection, how can we maximize protection at something minimal, which, can be a real challenge. Whereas, the client that's coming in that's well funded and, has, multiple levels of AI in the product, we have to figure out, all right, what's protectable, what's not protectable. And then there's always more to add to it. And then it's not even really a balancing act. It's just about, what's legally protectable and what's not protectable in the invention. So the thoughts are different, the goals are different, the needs are different. So, we try to balance that all the time. On the copyright side, we're what we're seeing right now, of course, is the ease of copying, not just from an AI standpoint, but just the ease of copying is something that a lot of our clients are worried about. We have a case right now where at first the claim was that the defendant's website kind of sort of looked like my client's website, and the product kind of sort of looked like my client's product, and it mutated into an amended complaint where it's cloned. It's now completely cloned for whatever particular reason. So the ease of copying on that side of life is a real concern for our clients.
And it's interesting you bring that up because obviously there's the brand side and then also the
Mhm.
legal side. So is there a unique way in how you balance the strategic legal against the brand building of technology companies?
Well, it can be difficult. So, for example, a a lot of companies, basically say to me, "Well, here's the trademark, and I need the trademark. I don't really care about protecting it, but I need it for Amazon," for example. And that gets to be very frustrating because a lot of smaller companies will have started the Amazon branding process, and I forget what it's called, and they've chosen something that they can't really register, because they didn't do the background work, and so they get caught in this particular rock and a hard place where, well, if they rebrand on Amazon, everything gets reset to zero according to Amazon. So they don't do the work beforehand, and they just started selling, and now they're going to have some tech consequences to that, to the legal consequences as well, which they rock hard place issue for our tech companies, our tech clients. I really sit down and I say, look, let's try to do our due diligence from the very beginning, because you don't want to finish your product, get it out on the market, and then have to rebrand after six or 12 months. And that's a real big concern, especially for tech companies. Once you get the social media ramped up, once you get the videos ramped up, once you start getting investors ramped up, you really want to make sure that you have that foundation in place. And that includes making sure your patents are filed. That includes making sure your trademarks are not just filed, but are researched, and you have your due diligence done to make sure, it's locked in. Even if, like, investors come in at some point and say, I don't like it is totally different than, well, I've done my research and I can protect it. And that's, I think, really important there. And then on the copyright side, right, you just want to make sure everything that is protectable, whether it's your code or videos, you've got to, register it. It's not that hard. Just register it, and then you can at least say it's registered. So, like, that's like on the brand side, you want to make sure you've done your due diligence and it's a brand you can use and protect.
That's some great info, Anthony. I really appreciate it. And it's a good segue into the industry trends that are going on. So, when you think about these companies that are doing launches, what are the major shifts that you're seeing right now in the world of intellectual property? And also, with that, how AI generated, just like you were saying, the content, the trademarks, and the digital assets is changing the game.
Yeah, I mean, look, on the AI side of things, obviously, the clients that come to us that are more well funded, come in with a whole bunch of AI algorithms, for lack of a better word. And the first thought is that, one, just because AI is involved doesn't necessarily mean that it's a protectable invention. Um, and look, we saw this when digitization first really took hold from a consumer standpoint. Like, if it's the same algorithm but a computer helps you do it faster, it's not going to be protectable. If it's the same algorithm but AI helps you do it 300 times faster, it's not going to be protectable. But if there is something that you can create that really does save manpower, hours, money, we those are the kinds of questions that we're going to ask our clients. About 10 years ago, we had a case called Alice that went up to the Supreme Court. And over the first half of my career, the Supreme Court would say things like, well, we're not saying all method patents, all algorithm patents are invalid. We're just saying this one is. And that happened like, four, five, six times. And at some particular point, they kind of got sick of saying that, and then this case called Alice came, and the Supreme Court said, well, you're right, an algorithm or a method has to be new, novel, and then out of thin air they added this language, have an inventive step. And where did that language come from? I don't know, but there aren't 9 intellectual property attorneys on the Supreme Court, so there's not much we can do about it. So basically, what's inventive to us? Well, that's what we say to our clients is tell us, what does your algorithm save? Does it save processing flops? Does it save money? Does it save time? Does it save, human resources? Talk to us about what that algorithm actually saves, and then we could figure out how to make it happen from what's protectable. So we're seeing that, on the AI side. You don't just say, well, AI is in it. We say, well, here's what the AI actually helps us. We invented this algorithm that involves AI, and here are the steps involved, and here's how AI actually works to do the thing that we need to do in our goal. It's subtle, but it's exactly what gets you over the finish line. And that's what we're seeing for our clients that are doing the high tech, the high tech stuff. Our clients our clients like in the toy industry, because obviously they're high tech toys as well, they don't come to us with the same kind of sophistication, despite being very sophisticated business people. It's just it's just different. So that's kind of what I'm seeing, is that everybody wants to protect what they're doing with AI, but that doesn't, just because you use AI doesn't mean it's protectable. You've got to be able to really define how the AI gets you to your goal better. I mean, look, we know very well that fashion companies are out there using AI to do design work, and not necessarily designing the shape of clothing, but maybe the patterns in our clothing. AI can easily generate 700,000 in different types of patterns on the same shape in almost no time. So we know that AI is out there in use in order to save human resources, and in some ways save some money. But you got to be able to describe that and describe each step in it.
Well, it's funny you brought up when you quoted as like expensive toys. I do robotics as a hobby, and so I have there's a robotic dog back there that I bring to work on, bring your work to or bring your dog to work day, which is always entertaining to see how the dogs interact with that one. But you kind of hinted at it a little bit. So you mentioned the Supreme Court and that they're lacking that intellectual property piece. So do you
Right.
think that the legal world is keeping up with the speed of technological change?
In some ways, absolutely. I mean, it's built in. In some ways, no, because we are lawyers. Look, I used to joke. I used to joke about a judge in the Second Circuit who was still writing opinions on Word Perfect for DOS, in the 2000s, and Chambers would have to convert the opinions before they went to the publisher. So if a judge in the Second Circuit is 20, 30 years behind in technology, does that mean they're going to be understanding the technology when a technology case gets up to them, because obviously if you're in a federal appeals court judge, you are, you do have some kind of seniority to you. So it's, you know, in some ways I do struggle there. In other ways, I remember coming out of law school, the Digital Millennium Copyright Act was passed in 2001, I believe, and I graduated law school in '03. And one of those aspects is that if you disseminated any formula for encryption, I mean, it was a crime. Well, that include so what people would do is they would print T-shirts with one of the more popular formulas for encrypting data on DVDs, and there were a couple really early cases about that being criminal, which is a First Amendment issue with the DMCA, and those enforcements were of course stricken. But like, again, older people in Congress writing a law for today, having issues, not understanding it fully, not maybe even reading the statutes fully, of course. So we do see those particular drags when when something new is popping up. On the cybersecurity side, a lot of states have started their own data protection statutes. And when we work on the data protection side with our clients, it's something that we have to be mindful of. California is the big one because they've got three separate statutes of their own. Obviously, when we work with our toy company clients, the Children's Online Privacy Protection Act federally is big as well. But every administration that comes along interprets it a little differently. So, it gets to be very frustrating at times because we do see when the law lags behind. In traditional IP, I do disagree with the people who say things like, well, copyright law just is passe, which I disagree with, because when people create things, right, we have our inspiration. We, wherever our inspiration comes from, we have our inspiration. We have the sweat and the work that we put into it. And I do think that as people, we should be allowed to protect that. And traditionally, what we say is, well, if a human makes the inputs into a machine and the machine makes it, well, the human gets, the ownership of the copyright. Now, we do change some of those things with end user license agreements and things like that. But again, none of that's really new either. So I think in some aspects, when we use our traditional principles, I think, we do tend to make it work fine. When we try to create new things to deal with new problems, I do think we wind up with, holes and flaws in the system. Try sending a Digital Millennium Copyright Act notification to any to any ISP when the domain name is information is blocked, and you're going to find yourself trying to send a letter to four different hosting and domain name registration companies, and all four are like, that's not ours. So it's there are times when certainly I think we lag behind, but I think our traditional principles also hold up still fairly well, even in our technological world.
When it comes to IP law, what do you see as like the most common misconceptions that entrepreneurs and creators are just incorrect about?
um so the number one thing on the trademark side is people who are filing their trademarks without attorney help, and then it gets rejected by the patent and trademark office. And in trademark parlance, we call that an office action, because the office has acted upon your application and basically tells you why you're not getting registered. And most of the time it's because your trademark or proposed trademark causes a likelihood of confusion with another registered trademark out there. So, generally, so basically, just because you file doesn't mean you're entitled. And that's the first issue. And if you haven't done your due diligence and you don't have a plan B, then you've got issues. So the first issue is coming to reality. If this is not a trademark that's protectable, you should find another. That's ultimately what it comes down to. And I see that trend much more so today than I did when I first started practicing, because when I first started practicing, the USPTO website was just information. You couldn't actually file your trademarks on the website, so you did need counsel. At which point we would say, well, we're not going to do this without us doing, and I still do that today. If you call me from the beginning, I will say, I need to do a trademark search, and I need to be ethical about whether or not you have the right to use the mark. And go from there. But back then, you kind of had to. And then once the USPTO opened it, which hey, everybody has the right to handle items themselves, and more and more people have started to do that. But now more and more people are realizing the problem. But now they're realizing it a year or 18 months into the process, which is a year or 18 months into the business or into selling the product or however it's defined, and now they're stuck between a real rock and a real hard place rather than a theoretical rock and a theoretical hard place. So that's the issue. On the patent side, again, we are just seeing people coming in with AI, and again, nothing inherently wrong with saying that your algorithm uses AI. It's just because it uses AI doesn't mean it's new and novel and inventive. It's actually being able to define the steps. It's actually being able to define the benefits, and being very, very specific about that. If we can work with you on that, then we're fine. But that's just one of the big misconceptions. Is just because you have AI doesn't mean it's new.
That's a good point. And I think everybody believes AI is just a new thing. So let's focus over now into Verna Law specifically. When you look at your company and its current state, what is working really well right now?
Um, I would say what works really well is the fact that we're small. It's because for us, clients can come to us and not feel like they're lost. And that's something that I like and appreciate very well with us being a boutique and having the small team that we do. Um, I also think that from the standpoint of what we look like, um, is you know two nerds. Sorry, Judy, our other attorney, Judy. She's not a nerd. I love her to death. She is inherently a media law litigator, which means there are things that there are things she fills in a lot of the cracks that Will and I have, because she's had 45 years experience as a litigator. A lot of her stuff is digital, but a lot of her work is not digital as well. So we really get to fill in each other's cracks, which is great and fantastic. And so from that standpoint, that's really what works well. What also works well is doing this. I have no particular fear of doing video, of doing podcasts, and you can see we have a podcast of our own. Although I do have six episodes in the can that I need to get out, but like all of this works really well for us because we get to just show who we are.
And one note for the people that are skipping through this video, when she said filling cracks, go back about 30 seconds and hear that whole thing just so you don't get the wrong idea. And it's interesting you mentioned that though, because when you talk about being boutique, that is actually specialized because you are that, small hands-on approach. So are there any processes or tools while being a boutique law firm that have been game changers for you and your team?
Um, I don't know that we have any particular formalized um processes that I think are a game changer or particularly different than any other firm. But what I certainly like on the patent side is that I have my bachelor's in computer science. Will Jakes, our patent agent, has his bachelor's in mechanical engineering. He and I both have worked in the fields that we have our degrees in. So I coded for two different companies before I went to law school. And Will was an engineer in the Navy before, on the civilian side for naval contractors is the way I should word that, before he decided to start taking classes and become a patent agent. And so you, you know we get it for the most part. We, for most of the companies that call us for their technology, we get it and we understand it.
What would you say most law firms don't understand about technology? So they call someone else and they
Well,
say, "Hey, I have this problem." What separates you? Like you just mentioned that background, but like what is like the key piece that your law firm is able to provide from that?
Well, I think a couple of things. One, I do think that most intellectual property departments just look very different from other law firms, or from the rest of the departments in the law firm when you're in a bigger law firm. And I do think that there's a communication mismatch anyway. So for us, you're coming to us for, your intellectual property. Period, end of sentence. You're coming to us for that, and we speak nerd with you, and we can overcome those particular obstacles because we do litigate. We understand the endpoint. We do licensing agreements. So your endpoints are something that we know and we see because we do it at the beginning and we do it in the middle and we do it at the end. With other law firms, even law firms that do like, corporate law issues. I mean, corporate law issues just work so differently than intellectual property that I just think there's a communications mismatch there. And for us, you come to us and we take care of our niche, and we make sure that it's done correctly.
Got it. So that's everything that's working well. So let's flip it to the other side. What has been like the most challenging?
The most challenging is, I would say on the litigation side is making sure that, you know, a lot of people don't quite understand, um, what their rights are. We do speak to a lot of people who are sued, for having one photograph that they, is not theirs, that they posted either on their website or on social media. And there are law firms out there that, do send demand letters based upon, one photograph. And, that to me has been the toughest, part of it, because a lot of people get frustrated and flustered. Like, you're in federal court over one photograph. And hey, I get those frustrations completely. But in today's world, you want to talk about digital things. If you're going on Google and you're pulling down a photograph and then you're putting it on your website or your social media, yeah, it's going to be a real problem, and it's a real issue there. So yeah, I mean, that's kind of those are kinds of the things that, we that really get frustrating for me in this particular practice, is like, we have seen an exponential growth in one copyright, violation, litigation, as as silly as that might sound.
What about in regards to like client education, scaling operations, or just adapting to that new legal technology?
Yeah, I mean, I think there's, I mean, in terms of scaling operations, I mean, we are really happy with where we are sitting right now. I mean, obviously, yeah, everybody would love more work to come through the door, and because it does mean, more money for everybody. But I think we're kind of happy with where we are right now, and I don't know that we're itching to grow more unless the opportunity is really right. I mean, there is a work-life balance that I do see colleagues in bigger firms, like, yeah, despite having more money, they have less time for themselves. And when you go on vacation, you want it to be a vacation. When you unless there's like an emergency, unless there's an emergency motion or order from court, you don't want to do that. So, from that particular standpoint, I don't know that we're itching to scale right now. I think all three of us are really happy right where we are. In terms of client education, I think, to me, that's the big thing, because a lot of people have a conception or a misconception of what intellectual property should be in their minds, and not really what it is. And especially with like trademark law and what a likelihood of confusion with another trademark is. And they're always like, well, that means I this other company owns the word. It's like, well, you didn't file the word Apple for this, did you? You know, I mean, let me conceptualize this for you. Because inherently you understand, that this is, that is something that is protected by a company. That's a gigantic company. And but then the analogy doesn't, quite get made into something else. So, education is going to be difficult, but I don't necessarily know that I have any particular thoughts on solutions for that other than continuing to do videos, podcasts, blog posts, and just try to get as much information out there as possible. But I know that's kind of patchwork.
I think that's a great transition into looking into the future. Let's start with the industry. So, what does the next 12 months look like in regards to its evolution?
um I'm not sure that I'm not sure that I've ever been right on any future predictions that I discuss, but I certainly do think that look, we've got some big litigation out there on artificial intelligence and copyright law. I certainly think we're going to be seeing more of that, especially because, look, AI has to learn from something, and a lot of that something is stuff that's protected. And I'm sorry, AI companies, when it's protected, and it can't be, used for what would be a derivative work. And at that particular point, the computer program is a derivative work. So I do think there's going to be some we're going to have some big litigation, some big decisions coming out in the next 12 months over the AI litigation that's been started. So how will that change copyright law? I'm not even going to begin to think about what those decisions are going to mean. Um, on the patent side, I just think it's going to be more and more. You gotta give me the results. I don't know that I don't see any big gigantic patent litigation coming down, and on the trademark side, we actually already had what was called the Trademark Modernization Act. And basically we have seen those changes already. Our time to respond to rejections from office actions was reduced from 6 months to 3. We're seeing filing fees go up at the Patent and Trademark Office as well. So I mean, it's getting a little frustrating, um, because a lot of small businesses are like, kind of scratching their heads over some of the fees because they can just jump a lot more quickly than they used to. So that we're already seeing those changes frustrate a lot of small businesses.
What do you think is driving the price increase?
Well, we have a couple things at the Patent and Trademark Office, at least on the trademark side, because the patent side really hasn't gone up. I mean, those can get astronomical if you're really wordy in your patent, but that's been true for a long time at this point. Um, on the trademark side, during the pandemic, we had a crush of fake applications coming in from China, a lot of which are still not disposed of, um, because A, they were fraudulent, and the question is how are they fraudulent? B, it created a backlog in the system. So, so some of these extra filing fees are to kind of help with that. The Patent and Trademark Office is one of the few offices of the federal government that actually make a profit. I mean, obviously, and philosophically, right, government's not there to make a profit. So, but this is, the PTO can run on its own right now. And so the idea is that, well, we need to keep running on its own, but also we need to keep trademark applications from being really, really wordy. And there were a few cases that just involved really wordy is I mean, it was like War and Peace was describing some of these products and services that were being claimed. And at some point the Congress decided to put, the PTO complaint to Congress, and then Congress, came up with ways to kind of crush some of those practices. So it was kind of multi reasons why the trademark side has gone up in rates.
Before we sign off, what final words of wisdom do you have for our listeners? What should they be looking out for? What are best practices? Things do you recommend as
Sure.
a legal counsel?
So, my first thought is plan. you know, when somebody comes to us with a new invention, I say, all right, great. What's your business plan? Now, if you don't have a business plan, that doesn't mean we're taking you as a client, but have a business plan, right? Because most patents, the dirty little secret, most patents don't make money. Now, a lot of that comes from some of our top tech companies that just file patents and then decide, well, it's nice to have, but it's not something we're gonna do. But a lot of it also comes from solopreneurs who never get off the ground. So number one, what's your business plan? If you're coming to us, what's your business plan? Make sure you have it. Two, you need to do your due diligence. You'll see the phrase patent search on our website. You'll see the phrase trademark search on our website. You need to do some background check, some background work to make sure that what you have is something that you can use and protect. And number three, I would say for us is making sure that a dialogue is always open and that just because we might use the word no doesn't mean that the door is completely closed. It might mean you need to, just think a little more. And sometimes that's all that it takes. But you have to have that dialogue box always open. We had a client like 2 years ago that I remember where we said, no, this is not really a new invention. It's not patentable. And man, the guy just like stopped taking our calls. And and we had some ideas as to what we thought, could get him over the finish line, but he just didn't want to hear it. And look, that happens. But just because we say no doesn't mean it's the door's closed. Keep that dialogue open.
I think that's a great point, especially for anybody going into entrepreneurship. That's never going to go according to plan. So you have to be able to take the punches and pivot
Right.
and go from there.
And right now we've got a client where like I said, I mean, we put together a patent application and they were like it was like the old TV show Columbo. Hey, one more thing, and that one more thing turned into like 10 hours of work, and then we put it together, and they were like, hey, one more thing, and that and that happens as well. So we even though we try to coax everything out of our clients to see like how many inventions there might be, it's always kind of funny. It's like, oh well, we have this other thing, and then all right, so yeah, that happens too.
All right. Well, Anthony, this has been awesome. I really appreciate all of your insights that you've shared, especially about the evolving world of intellectual property, because it's a really cool angle for our show.
Thank you, Darren. It was a pleasure to be here.
The pleasure was all mine. For anyone listening, you can learn more about Anthony and his firm at vernalaw.com. We'll have links down in the description so you can find out all that good information. They'll have great resources for their trademarks, copyrights, and business protections, just like we spoke about at the beginning. And as always, oh, goodness me, my tongue is just failing me today. But as always, thank you for tuning into the Digital Shift. If you enjoyed this conversation, make sure to subscribe and share it with a friend who's building or protecting their brand online. You have great access already to a firm right here on the show, but you can go learn more about them from there. So again, Anthony, thank you so much for being on the show. It's been a real pleasure.
It's been a pleasure. Thank you so much, Darren, for having me.
Hey there, it's Darren from The Digital Shift. I wanted to take a moment to thank you so much for listening to today's podcast. If you haven't already, make sure to check out the links in the description to learn even more information of everything we went over today. But if you enjoyed this podcast, then you are absolutely going to love this one. And if you're looking to look deeper into the technology that we go over in these videos, then go ahead and check out this one here. Regardless of which one you pick, you're going to walk away with something new. As always, I'll talk to you in the next one and keep being awesome.